With the data protection regulation on the horizon, I often ask myself what data protection means to me. First and foremost, it means to me what it says on the tin. It's all about protecting people's data. And that breaks down into two high-level rules. First of all, respecting people's privacy, and secondly, never doing anything with their data that they will be surprised to hear about. For me personally, it also means an exciting journey that I embarked on nearly 20 years ago when, as an ordinary advertising and media lawyer, I realised that this data protection thing was going to get quite big and that I really needed to make sure I knew about it and become a data protection lawyer as well. And over the intervening years, I tried my best to keep up to date with developments so that I'm always there for advertisers and marketers who need help with the increasingly complicated rules that apply. Marketers should care about the data protection regulation because whatever form the final measure takes, and we're now being told, by the way, by the Information Commission that the final measure won't be in place and possibly until the end of 2016, therefore it won't be in force until 2018, but whatever form it takes, it will certainly increase the protection that's given to people's information. That means that it's going to create new challenges and risks for marketers. The first big challenge is going to be the change that's going to happen to the definition of consent. In every single draft of the measure that's being debated, and have been debated since 2011, explicit has been an additional rule in the new measure. So that's going to create particular challenges for marketers, especially when we've got a situation where increasingly sophisticated marketing techniques, so-called ad tech processes, are challenging even marketers to understand how they operate, let alone consumers who are supposed to be giving informed, explicit consent to that happening to their data. The most important aspect of the data protection regulation for the one-to-one marketing sector is the message it sends to all those in that area that it's time to wake up, get real, smell the coffee, and make sure that data protection is embedded in the beginning, middle, and end of every single marketing process. Also, a related element is privacy by design and default, and that's the title of one of the articles in the draft regulation. So it's got to be a default consideration that comes into every discussion about a new marketing campaign, for instance. When we advise clients about becoming compliant with the new regulation coming up, what we say is that the detail of the regulation is still not set, but the main thing they have to do is make sure that they're complying with the current rules, because if they aren't, it's going to be a real challenge for them come 2018. So, interestingly enough, the Information Commissioner's Office has just this week published some guidance about the key areas for businesses to look at right now in order to get themselves set and ready for 2018. Two or three of the areas that ICO has mentioned are, first of all, what they call consent and control. Are you right now making sure that customers and individuals whose data you have know what they've consented to in terms of the use you're making of that data? Also, are you giving individuals control over their data, for instance, giving them an easy way of opting out of their data being used for marketing, which actually is a legal right under the current legislation? Secondly, they talk about staffing. Have you got the right people in place who are going to be there to help you come 2018 and as of now to help get yourselves up to speed and make sure you're compliant? Either hire in people with the necessary expertise or train up your existing staff to make sure you're ready to go when the time comes. When I look at whether the regulation will have a negative or positive impact on the UK economy, I'm currently really quite concerned. That's because I believe that there is still in the draft regulation being debated an over-formalistic box-ticking approach and also an almost messianic antipathy towards things like profiling. On that aspect, there's a much wider definition of profiling, and also provisions which are going to impose significant obligations on marketers to give particular disclosures to consumers before they can validly consent to their data being profiled. That's going to be a significant challenge. However, the UK government is alive to these concerns and has been negotiating furiously to make sure the measure ends up being a much more pragmatic and even-handed measure, and I do hope at the end of the process we'll have something that will be fit for purpose for the 21st century, give consumers fair protection for their data, but also not put an unfair straitjacket on compliant marketers who want to just behave reasonably.